Welcome. I'm David Ricks. I'm a personal injury trial lawyer in Rancho Cucamonga and the principal of the Inland Empire Law Group. I want to talk about a concept called the burden of proof. Now, in criminal trials, we hear the burden of proof meaning beyond a reasonable doubt. In other words, a jury should not convict a defendant unless they are convinced beyond a reasonable doubt that the defendant was responsible for the crime alleged. In a civil action, it's a little different. There's still a burden of proof, and the plaintiff or the person who's bringing the case has the burden of proof of proving his or her claim. But in a civil action, the burden of proof is a lot different than in a criminal action. So let's take a look at what it is in a civil action. In a civil action, the burden of proof is a preponderance of the evidence. In other words, it is more likely than not that the events alleged by the plaintiff actually occurred and that the defendant is responsible for the injuries caused. If you were to have the scales of justice in front of you, in a civil action, the scales would just weigh slightly more in favor of the plaintiff than for the defense. If that's the case, then the plaintiff has proven his case, or the burden of proof has been met. If the scales are equal, then the burden of proof has not been met. Or if the scales balance the opposite direction in favor of the defendant, then the defendant will win the case. So when you take a case to trial, you're going to have to prove your case by a preponderance of the evidence, or in other words, that your story, your information is more likely true than not true as compared to that of the defense. If you have a good trial attorney, that trial attorney can help you meet that burden of proof and maybe even exceed it so that there's no question that you'll win a trial.